Welcome everyone. The specific seminars that we've been running have been really great for our customer engagement, engaging with the industry and trying to let everyone know the current issues that are surrounding the operations of their businesses. So that's been really, really great. Last month's was all about bundling, the pros and cons of bundling, and those videos are live on our YouTube site. We've had in excess of 300 views of those, and if you want to just go to our website and click on the YouTube link, you'll find those videos from last session. We are videoing today's session, so you'll be able to review it, and for those of you that couldn't make it today, you'll be able to review that. That'll be up on our YouTube site within about a week or so. For those of you that I haven't met, my name's Justin Owen. I'm CEO and co-founder of REI Master, EasyRes and REI Cloud. I've been servicing the industry now for nearly 20 years, so since 1999, of all things technology relating to management rights and property management. So quite some time. Just a few housekeeping items. If you wouldn't mind making sure that your phones are switched off or at a minimum to silent as a courtesy to our presenter today. I've done a lot of these sessions and I totally understand that in the middle of a session like this, the lift will stop working, or there's some major drama at the complex, or there's that owner that you really need to speak to, you haven't been able to get hold of, you're trying to get into your letting pool who chooses right now to call. We totally get that, it's normal. So if you need to take a call, please do so. Just go out to the foyer there and then come back in. That's fine, that won't disrupt us at all, no problem at all. Toilets are just out through the double doors there to the left. Bit of a disclaimer, we are doing a legal presentation today, and this presentation doesn't consider your individual circumstances, and you should get specific advice from your advisor relating to your specific circumstances. So there's my disclaimer there. We will have a question and answer session at the end of today. So a little bit about our presenter. Frank, welcome. Frank joined Hynes Legal in 2001 and became a partner and director in 2004. Right. And has made what's been a really great decision for his business to focus on two key areas, being body corporate law and management rights, and is considered one of the foremost experts in his field in Australia. So we're really, really grateful to have someone of the quality of Frank join us today. Frank often speaks at ARAMA events and is a panel member for ARAMA as well, which I think is really important from an industry credibility point of view. But I think really importantly, from a peer-to-peer level, Frank recently appeared in Australia's Best Lawyers list for 2018 and 19. Which, considering the number of people in the legal profession and the quality of those people in the legal profession, I'm sure we'd all agree is a big deal. So there's a great introduction for Frank. Welcome, Frank. I'll hand over to you and we'll hear all about the management rights deal killers.
Thank you, Justin. Cool.
That button there,
cool.
On the left. You click
cool. And thank you everyone for coming along. Almost feel a little bit nervous. Haven't spoken to a crowd this big for a while. So Murray is the furthest traveller. You've got a free will, well done. But I suppose for me, part of my job is to make my life easier. And hopefully each of you will take stuff out of this today that will do that when you come to sell. So whether I'm acting for you, acting for your buyer, acting for your body corporate, heaven forbid, but really, there's a whole lot of things that we continually get in management rights deals that cause grief. And it's a stressful process selling. You know, you've put all your paperwork together, you've got a price expectation, you're on the market, you're doing inspections, you're getting kicked around, you're having people belt you down. You then finally get to the contract stage. We've got 60 to 90 days to move house, to find out where we're going, to transfer all of the bits and pieces that we need to do, transition to wherever it is that we're going, and the last thing you need to deal with is the stuff I'm going to be talking to you about today. And the joy is that most of it you can actually manage up front. Some of it you can't, and you just need to be aware of it, but a lot of it you can. So my aim today is to give you a hit list of things that you can go back to your complexes with and start managing now. So for me, preparing for a sale doesn't happen the day you list it. Doesn't happen the day you sign a contract, because it's far too late at that stage. You really want to be doing this stuff 12 months out. Know where you stand, or perhaps even 2 years. And part of it for me also is that if you've got that time frame of we're going to sell inside 2020, we're going to market, this is what we need to be ready for. Sometimes there's circumstances that come from left field that mean you've got to sell ahead of schedule. Those can be personal circumstances, ill health or otherwise. The other and more preferable reason is a broker knocks on your door and says, I have a rockstar buyer for your complex, here's an offer that is too good to refuse. And if that's the case, you also want to be ready. So for me, there's a whole lot of stuff in here, and some of you might have seen me do this presentation before. As I bounced around our team in terms of what are the issues we're getting, they came up, and there's actually a few new ones. So surprisingly enough, I'm going to start with this slide, and that for me is effectively what every sale is about. So if you're playing that on a triple word score, that's a bad thing. If you're, from a sale perspective, buyers come to you based on what you've told them. The business is netting this. I have a term of 21 years. I've got a great relationship with my body corporate committee. The unit's worth X, so on and so forth. People believe you. So 99% of people will. There's some people that are being completely burned and will never trust people again, but the bulk of buyers believe what you're going to tell them. So when you let them down in the context of what you've told them is not what they're actually getting from a due diligence perspective, it just crips away at that relationship of trust. And from a sales perspective, once you sign a contract as a seller, you're committed until those conditions in favour of the buyer pass. So we've normally got, probably at this stage, a 14-day verification, maybe 21 or 28-day legal due diligence period. And I'll talk about finance, but finance is probably about a 6-week process at the moment, as painful as that might be. So you're on the hook and can't walk out until the buyer has exhausted all of those options, but the buyer has 6 or 7 weeks to get cold feet. And they will get cold feet if they find on the way through that the things you've told them or the things that your broker has told them aren't true. So to me, again, this preparation today. Preparation for your sales should start now. And some of this stuff you can do today, and it's all good. But starting with, and I'm sort of walking these through in order, the verification amount itself. We're netting 180, it comes in at 150. Like that, for me, is relatively unforgivable. In terms of why that happens, 1,000 different reasons. People doing their own figures include 13 months instead of 12. We've got the wrong body corporate remuneration. We're adding GST in as revenue but not taking it off as expense. It goes on. So that is the very first thing that will kill deals. And it's really hard to overcome at times. So if you've got a business that you think's netting 180, it's actually netting 150, it's 30 grand less than what the buyer thinks it is by the time they actually get to the stage of getting their accountant's report. Normally one of 3 things will happen. If it's a small amount, grand or 2, the buyers normally will just accept that, walk on, waive the condition and keep going. They might terminate. And usually they'll give you a chance to negotiate that, but if the discrepancy is big enough, and for example they need a certain amount of revenue or profit to make their lifestyle choice work, or to service their debt, or to service what they owe on their other house, or whatever it might be, that 30 grand going missing just might kill it for them cold. Nothing they can do. And so you've wasted your time, they've wasted their money, you're 4 weeks behind in where you'd otherwise be in terms of a sale, and that's a bad thing. But more often than not, if that figure's somewhere in between, you're $1,000 short to 30 grand short, there's going to be a renegotiation go on. Now that renegotiation, ideally for me, is run through the broker. It is painful to negotiate commercial terms through lawyers. Like, I'm good with legal stuff, I can get to the nub of a legal issue really quickly, but when it comes to what someone's willing to pay, and acting on the buy side, what I'd be saying to a client whose verification is 30 grand light is really, you're back to where you were 4 weeks ago, you've found a business you like, but it's actually netting 30 grand less than what you thought it was, so what's that worth to you now? So for me to negotiate with another lawyer, I need to put something on letterhead, it needs to go through to them, they need to go to their client, they need to come back to me, I need to go back to my client, we go backwards and forwards playing ping pong. Much easier to get the broker involved to try to cut a deal straight up and hopefully earn that commission that they're going to be trying to earn because they've absolutely got an incentive to sort it out, because if it doesn't settle, they don't get paid. So the brokers are generally pretty good at doing this. And I can tell you that, and this is more human nature than anything else, again, back to that $30,000 net, say we've got a multiplier of 5, that's $150,000 worth of capital value that's notionally gone missing. 90% of the time, 75 is going to be the number that it gets resolved at. That's it, that 50% discount on whatever the difference is where most of them finish. So that's just a little bit of human nature. And in terms of solving this, so again, for me, it's solving problems. And I know professionals charge, hopefully I'm one of those, accountants do. If you've got accountants' figures, that will solve, to me, the bulk of the vendor mistakes we see. That's that 13 months, that's including additional remuneration, that's including GST, that's whatever it might be. If you've got an accountant to do that, and then updated accountants' figures. Now this, again, in terms of how often you have to do this, it's really up to you. You need to be guided by your broker and potentially the market. But from my end, in permanence, it's probably not as critical to have them done, because the revenue line from a permanent side of complex, provided you haven't lost letting appointments, is going to be there or thereabouts. Obviously, short-term lettings are a completely different proposition, subject to peaks, troughs, shoulders, and so on and so forth. But if you've got a buyer bouncing around comparing businesses, and they've got a business here with figures through 31 March, and they're comparing it to your business with figures through 31 August last year, that's just one tick on a box from a buyer's perspective that will attract them to the business with the most recent figures. And in terms of updating figures, I haven't had it for a while. Normally, vendors that do their own figures tend to be on the high side. We did have one. There was a holiday build up on the sunny coast a couple of years ago where the vendor had done their own figures, working for the buyer, complete insanity. The accountant verified it as 30 grand more than what we had in the contract. So they'd let it drift, they hadn't updated their figures, they'd clearly had a good period. So suffice to say, at that stage, our client said, just make it happen, and we did. So they're up 150 grand the day they start. Be guided by your broker, but if you've got those two sorted, what that then gives you the ability to do is know for certain what it is that you've got to sell. And I can also assure you that from a buyer's accountant side of things, they love tearing vendor prepared figures to pieces. It's much easier if your accountant can have a conversation with the buyer's accountant about what the discrepancies actually are. And at that stage, you drill down pretty quickly, and particularly when you get to the stage of adding back things. If you're adding back lifestyle choices, adding back staff, all that sort of stuff, if you've done that yourself, the buyer's accountant's going to be a lot harder on those figures than what it is if it's been prepared by another accountant. That's just the way it works. So the more complex it gets, the more you should have those updated and the more accurate it's going to be. And so if we're out by $1,000 or $2,000, it's never fatal. If you're out by 30, it absolutely is. And don't just, that's back to vendor prepared figures, don't just download them from your MyOb and say that's it, because that is never ever right. Now, into a little bit more detail from a verification perspective, and I don't know whether it's the mood of the market or just accountants getting more detailed, but again, what we get now from most accountants when they're preparing or doing a verification of figures is they will actually go through the letting appointments and make sure that what is being charged to owners is what's actually recorded in the appointment itself. And you would be surprised how many times it's different. So Justin, this is one for you at some stage, not for you to audit, but owners negotiate. The commission might normally be 8% across the board. Someone's negotiated 6.5%, but someone plugged it into EasyRes as 8%. Someone's negotiated no postage and petties. It's been plugged in at 7% per month like everyone else. So what we're now getting from an accountant's perspective is confirmation about whether the numbers stack up or otherwise. And there's a schedule at the back in terms of lot 1, tick, 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 cross. We're missing the $7 a month postage and petties. Tick, 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 no repairs and maintenance. And all the way through. And again, it's a bit proportional in the sense of if you've got 100 units and 3 of them are a little bit defective in terms of we don't have postage and petties, it's not the end of the world. if you've got 100 letting appointments and 70 of them have the little bits of yellow that the accountant has identified as missing issues, that is going to cause an issue for a buyer. And to be fair, this is something that has probably been emerging, I'd say, over the last 12 to 18 months, starting to see it a lot more, which means that those of you that bought perhaps 4 or 5 years ago or have signed up new appointments in the meantime haven't necessarily been through an audit of that nature. And where we get to, subject to where everything else fits into the mix from a verification perspective, buyers aren't too difficult about it, provided there's not too many of them. But you can rest assured that buyers will normally ask you to go back and deal with those issues before they settle, or use your best endeavours to do it. So can you go back and get the appointment for lot 7 to include the $7 postage and petties? So again, that's $84 over the course of the year, but then when you have 10 of them, that's $840, and when you multiply that by 5, we're getting up there, and then you add this, it just all sort of adds up. So again, from a cure of this perspective, this is a very easy one to get in charge of. It's a simple thing of auditing your appointments. Now that's not your trust account auditor that will do that. They just want to make sure your trust account's being used the right way. In theory, they probably should, but none of them actually go through this to my knowledge. So for me, it's a matter of you or engaging your accountant to do it, to get your appointments and make sure that what's in your computer system and what you're charging people is consistent with what's in the appointment itself. And ultimately, it's the appointment that matters. What that says is what you can charge, no more. So making sure that's done is another little tick on the way through in terms of the verification, because we're getting a lot of conditional verification approvals at the moment, obliging sellers to go back and try to sort these things out before settlement. And again, when you're in the middle of doing all the other bits and pieces you need to do, having to go to 20 owners and ask them to initial an appointment to allow you to charge $7 here or $30 there, or even one the other day, none of the appointments referred to GST. So we're charging 7% including GST, rather than 7% plus GST. So going back and asking all of the owners to sign plus GST, which is 10% of the revenues, that was a relatively big thing, is just a pain in the backside, particularly when you can control it now. You can be in front of this. So to me, audit your appointments, go and sort them out with the owners now, and that serves 2 purposes. 1, it's great from a verification perspective, but 2, it's also great from an OFT perspective. If someone complains, an OFT comes and does an audit and says, well, you're charging people more than what your appointments allow. That's the very last thing you need. So that's good business practice in itself. Now, this still is an issue. So we have 3 versions of letting appointments out there at the moment. So that's a Form 6. So that's been in place since November 2014 when the Property Occupations Act arrived. So that's 3.5 years ago now. So what we're getting from a verification perspective is a mix of appointments. So we're getting letting pools that have PAMDAs, or PAMDA 20As, and letting appointments or letting pools that have Form 6s. So if you've bought a new business in the last 12 months off the plan, you're all going to be on Form 6s. But if you've been around for longer than that, you probably will have a mix of letting appointments in your letting pool. Now, a PAMDA appointment that was valid at the time it was signed is still valid under the POA. So if you've got a PAMDA from 2006, that is still a valid appointment today if it was signed then and it was valid at the time. So that's all good. But first rule of this Fight Club is if you don't have a letting appointment, you cannot charge anything to your owner. Black and white. So the same as if you're involved in real estate sales, you can't charge a commission unless you've got a Form 6. The same as when you go to sell your management rights business, the broker will get you to sign a Form 6. If they don't, they can't charge you a commission either. The same rules apply to you. So I've had this twice, I suppose, in my management rights career, where clients have rung me, so-and-so, been acting for him or her for 5 years, I don't have a letting appointment, they tell me I've got to give them back everything I've charged them, what do I do? So you give them back everything you've charged them. No argument. There's no quantum merit stuff in terms of, well, I've done the job, I'm entitled to be paid something for it. No. The Act says if you don't have an appointment, you cannot charge for it. So make sure you've got an appointment for every single owner in your letting pool. Because I can guarantee you the outside agents will. And so for me, first rule here, go back, make sure you've got an appointment for every single owner. If you don't for a particular owner, to me the line would be, I've been to a seminar this morning, I'm told I need to have one of these in place. Previously I've been operating on a handshake in effect. I need this back before I can give you your disbursement at the end of this month. and then ride them. Because what's going to happen is you will come to verification, the buyer's accountant will point that out, and the buyer more than likely will ask for a discount on the price because you don't have a valid letting appointment. That's becoming more and more common. So clawbacks is the next thing I'll talk about. And they're pretty easy to get. Most owners, some people don't like putting pen to paper, I get that. Some people are overseas and don't understand it. The problem is that it becomes a massive problem for you when you go to sell, or when that person complains to OFT about something that you've charged them and you don't have an appointment to do it. So that applies for everything, but from a PAMDA perspective, we've effectively got two different versions of a 20A. So one's before, I think it was 2011, we previously used to live in this void where the Property Agents and Motor Dealers Act didn't expressly deal with whether letting appointments could be assigned from manager to manager or from agent to agent. Now, I think it was in 2011 we did get that, so you'll find there's two different versions of 20As. There's the pre-2011 version, which doesn't have a section 4.4 on it, and then there's a post-2011 version which does. So what you need to do is audit your appointments. When you go home, make sure, and you can add this to the previous slide in terms of making sure all the I's are dotted and T's are crossed. Starting point, you must have an appointment for each unit. If it's a 20A, you want to make sure that the section, a newer 20A, section 4.4 is ticked and initialed by each of the owners of that property. And that means then that appointment is assignable to your buyer. Because from a legal perspective, if that appointment's not assignable, the buyer's going to probably, again, condition their verification to say, unless that's assigned to me at settlement, I'm not paying for it. That's just what we're dealing with at the moment. And the accountants are being that picky that if there's two lot owners and there's only one initial, they're going to say that's not assignable because both owners haven't signed it. And then there's the pre-2011 20As, which don't have that section 4.4. For that to be assignable, there needs to be a separate sheet basically where the owner agrees to make that assignable and signs it or initials it and gives it back to you. You staple it 20A, you're done. If any of you have those old school appointments that aren't assignable, I can flick you that little wording on email you need for free. You just need to send me an email and I'll bounce it back to you. But that's the thing. Make sure that every one of them's there, every one of them's assignable. So Form 6s automatically are. You just need to then check your two versions of the 20As. Ideally, that was done when you purchased your business and subject to you know, where the market was at the time, where you were at the time. You might have made a commercial decision to proceed without some of these things being in place. It's going to be a hell of a lot easier if you've got them all in place now by the time you go to sell. Again, you don't want to be dealing with going to have owners sign new Form 6s in the middle of trying to get your business sold. One little less bit of grief, leaving aside, it's bloody good business practice to make sure that you're actually going to get paid for what you do. I mean, if we're not going to get paid for what we do, you might as well be on the beach. I've got better things to be doing. I'm sure you do as well. And people, and they're probably law students, do understand those shortcuts and will be the ones to hold you to account. So doing that, you can do now, really easy and very solvable. Now, clawbacks. So this is something new. When we're putting together a contract or a deal for someone to buy a business off the plan, we have clawbacks and claw forwards, which are really another way to say adjustments of price based on letting appointments. So when you're buying a business off the plan, you know you're going to have the caretaking salary. You've got a caretaking agreement that says you're going to get paid 100 grand a year and you can apply a value to that. What you don't know is how many letting appointments you're going to finish up with, because the developer might have 100 units to sell. They're going to tell you without doubt that most of them are going to finish with investors, like all developers do. But the proof in the pudding is the actual number of Form 6s you've got on the day of settlement that have settled. Now that could be 50, 20, 30, whatever. So when we're buying things off the plan, we put in place a mechanism to pay for what's there on the day, have an adjustments probably monthly for a period of time for up to 12 months as new letting appointments come in the pool, and we apply a value to each letting appointment. So each letting appointment might be worth 10 grand. So once you get a new Form 6, you pay the developer 10, you've got what you paid for and away you go. And after a period of time, that falls out. Now from a management rights perspective, there's obviously a little bit of a management rights mafia. Certain number of lawyers, accountants, banks, finance brokers that probably do 95% of the business in the industry. So we're one of those, there's some other people too. There was a big conflab, November last year, where everyone got together. Unfortunately, I couldn't go because I was on a golf trip, which was a much better place to be, where this was discussed. And so a couple of people are pushing the proponent that we should be having price adjustment clauses in management rights contracts for existing businesses. So that if letting appointments drop out of the pool, from when the verification is done through to settlement, that there'll be an adjustment of price. Now that will be a rather large change to industry practice, because that is not what happens at the moment, and probably, to be fair to say, is not what's happened for each of you on the way in when you bought. There's a couple of people pushing it. My personal view is, I think it's people trying to tell people how to negotiate. One of my things I will not do is comment on price. I'm not a valuer, I've never seen the business. To me, this is another way to comment on price, but it's there. So to me, couple of things in terms of how to deal with this. Firstly, it's to nail down at the offer and acceptance stage whether the buyer is going to be looking for one of these things, and in that sense you'll need to be guided by your broker in terms of whether they've got people around them that are going to be recommending it. I would name names, but I won't do that. It'll be a little bit unprofessional of me, but if we're acting for you, I will know and will tell you. And if there is, it's the time for that conversation is when the offer and acceptance is being put together. What we're getting at the moment is in the middle of two deals at the moment where the buyer's lawyer has dropped a clawback on us 3 weeks after the contract signed as a condition of the verification. Just cold, without any, no units on the market, nothing for sale, but bang, we want this. So that's upsetting a few apple carts, and we'll probably work our way through it. So for me, if it does get lumped on you, the problem you've got is, as much as it mightn't have been what it was when you bought, that's what the buyer's being told to do. And so I had a client years ago that said to me, you know, if I'm paying a dog to bark, I'm going to listen to it when it does. So if a buyer is getting advice that you need one of these things, then for me, they're probably going to listen to that advice, and it's a question of whether you'll agree to wear it as a seller, and then, if you will, the negotiations about it. And so for me, the first thing with a clawback in terms of a price adjustment down, if units are lost, is, well, what about an increase in the price if we pick up more appointments? Because to me, having the benefit of the downside without the upside is having your cake and eating it too. Certainly in terms of the standard clause that's being used, they do offset to there's a number of appointments, but we have one of these 12 months ago, we ended up having 2 more on settlement that the buyer then squealed about, but they'd done the deal. So the pushback to having a price increase is going to be, but we don't have finance for it. The answer to that is, we'll go and get your finance in place now to do it, because you can make an application for an increased amount and we can cap the number. We can say no more 2 down or up at a number. So you can go and apply for that. The second thing is the actual value of the amount. So the traditional way to calculate a clawback is from a management rights sale P&L, we've got caretaking salary. That's going to be there rain, hail or shine, so we don't need to worry about that. Then we've got letting income, we've got letting costs, and we've got a number of letting appointments. So if you get the letting income, take away the letting costs, we've got audit, licence, software, etc., 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 divided by the number of letting appointments. That's the theoretical value of each letting appointment itself. Now, whether that's the actual number you end up using or not is something else entirely. So that might work out to be 7,500. The clawback number you could bring back to 5. Because this is all part of the commercial mix in terms of, well, I wouldn't have signed a contract at this multiplier if I knew that I was going to run the risk of losing appointments at the back end. So that's all part of that negotiation that, to me, we should be trying to have at the offer and acceptance stage if the buyer's going to impose it. So you need to be guided by your brokers on that, because they are starting to deal with it. Or if you're a direct deal, and we're seeing a few of those, me, if I'm acting for you. But just be ready for it. So that's brand new, literally has only started appearing in contracts in the last couple of weeks, despite it being discussed last November. So that's one that you can't necessarily prepare for, but as John Howard would say, be alert, not alarmed. Just be ready. Then we go on to this. So this is Gallery V. And this is not going away. So I've got a little bit of time today, so I'll give you all the rundown on this. So what happened at Gallery V is the business was sold. The buyer financed through Suncorp. and the person who bought the business also got some vendor finance from the seller. I think it was about 60 grand or so. So they didn't quite have the equity to chip in. So they had a first to Suncorp, borrowed some money from the seller, 60 grand. Over a period of time, they chipped away obviously at paying Suncorp, as you have to. You can't not pay your bank. They started to get a little bit recalcitrant in terms of paying their seller. So the seller sued them. You owe me 30 grand, where is it? That got really untidy, judgment was entered, everyone started, well, handbags had been thrown, and Suncorp said, you know what, this is starting to affect the value of our security, we're appointing receivers, bang. So they put receivers in to run that business and said to the seller who was owed the money, you can go and sit in the wings and get stuffed. What then happened is the seller appointed a liquidator to the company that owned the management rights business. So at this stage we had a receiver sitting there owning and operating this thing. We had a liquidator sitting on the company waiting for Suncorp to do what they had to do and sell it, and then the liquidator would then finish off whatever was left in the company. So there's effectively two corporate undertakers feeding on the carcass of this company. Now banks have statutory protection under the Act for their security, because from a bank perspective, when they lend you money on real estate, they know that real estate, well, particularly in a body corporate complex, is always going to be insured, is not going to burn down, and they've got real things that they can go and execute against. They know that that unit is still going to be there tomorrow, next week, next month and next year, which is why we get 30-year loans and all those sort of things. Management rights businesses are a slightly different proposition in terms of their value is tied back to the continued existence of those agreements themselves. So if those agreements are terminated, what you've really got is a month-to-month caretaking salary and a bunch of letting appointments that are effectively a rent roll. And that horribly devalues the business. So banks, as part of the BCCM in 2003, negotiated statutory protection. So what they have is, and you don't see it, it will be part of the documents you sign when you buy a business. There's a notice you sign to the body corporate that once the settlement's affected, the bank sends, it's a 123 notice, so a very easy number to remember, to the body corporate and says, we've got an interest in this business and you now can't terminate these agreements unless you give us a chance to remedy the default. So what that was negotiated at the time is if the receiver steps in, they've still got to do the job. So if they don't do the job, the body corporate is entitled to issue breach notices and all those sort of things and hold whoever it is to account. But by and large, the bank sits there imperviously saying, we're not going to be victims of whatever the person who owned this business did. And this is where they came unstuck. So it's a very rare set of circumstances where someone, in my experience, knowing there's a receivership in place, would go and appoint a liquidator because they're expensive things to do, almost out of spite. So, and these management rights agreements had the typical sort of termination provisions you see. So lawyers love documents and words, so boilerplate provisions appear. So under the Act, really the only ways to terminate a management rights agreement are you don't do the job, you're not licensed as required by law, or you're convicted of certain types of indictable offences, like assault or dishonesty. That's it. Management rights agreements normally then go on to include additional provisions. And the typical ones that appear in lots of commercial agreements are where the counterparty, being the manager, is bankrupt, insolvent, has a liquidator appointed, goes into receivership and so on. So what happened here is this agreement had those provisions. Suncorp appointed a receiver. The seller went and appointed a liquidator a couple of days later. And then when there was a dispute over what actually happened, QCAT said, well, Suncorp took possession. That liquidator was appointed on their watch. There is a right to terminate for the appointment of a liquidator, and therefore Suncorp, you are potentially going to lose your right under the agreement. And that threw the cat amongst the pigeons from a management rights lending perspective, and is still doing so. So that, and I don't know if the newsletter's in there, but if not, I've got a whole newsletter on the website, you know, did you hear the rumours about bank lending, that talks about what happened. But in essence, that's what happened. And then banks listened to their lawyers, and we got a whole heap of new credit policies that have caused grief ever since for management rights agreements that have Gallery V, or that aren't Gallery V compliant. So, I've lost count of the conversations I've had with clients as sellers or owners of businesses, because what we do is recommend to everyone, I'm telling you all here today, you need to fix your agreements for Gallery V. Clients will tell me, no, Frank, that's a buyer's problem. That's only because of their bank. And it's like, well, in theory that's yes. If the buyer wasn't borrowing money, we wouldn't have any Gallery V issues because we don't have a financier to care about them. But the reality is that 99% or 100% of management rights buyers do borrow. They're going to go to one of these banks, and that bank's Gallery V policy depends on what the buyer's experience is, how much the buyer's borrowing, what their other security is, what the bank's particular mood on the day might be with respect to Gallery V is. So if you're trying to say that that's the buyer's problem, in theory it is, but it becomes your problem if you can't sell to them because your agreement's not compliant. So to me, you must deal with it. So there's two ways to deal with it. One is to remove the offending provisions entirely, simply delete them. The other is to water them down to say that they will only apply to the extent that, or they don't apply where a receiver is appointed. And to me, that's probably the less confrontational way to go. Because when you get into the nitty-gritty of this, and when you get asked the question from a body corporate, and to be honest, we've probably done this, I don't know how many 100 times since that decision came down. And each of the banks, they're getting more comfortable with it, but there's still some banks that absolutely will not lend if it's Gallery V. Cold. So what you do is if your buyer only wants to go with one of those banks, you're in trouble. We've lost, we've had clients lose 3 times on Gallery V amendments. So that's an astonishingly small proportion. The first 2 times was the body corporate went and got a lawyer who didn't understand what was going on and scared the daylights out of the committee, and then the committee knifed it. We've got one of those coming back around again soon actually, so that'll be interesting. And the third one, our clients get on famously with everyone. And what the committee was doing behind their back that they didn't know was running around, knocking on doors, telling all of the owners, if you vote this through, they're going to sell, and we don't want them to go. So we got belted for providing excellent service. But we got that one through a couple of weeks ago. So we've cured one of those 3. The rest of them we've got through, and that's not to say some of them haven't been without some selling. So, and the sell for me is this. When you look at it, what the body corporate's been asked to do is give away a right to terminate that would otherwise exist. Now that right to terminate is very discreet, very remote, and you look at the circumstances of Gallery V, that's the very first time that's happened in 20 odd years of BCCM Act. So chances of it repeating again are pretty remote, particularly where banks will not lend money when there's vendor finance involved anymore. So don't bother trying to do one of those deals because they are dead. So when we get involved, from my perspective, and this comes back really to that first slide in terms of trust, if your owners trust you, and that's owners, not investors, that's everyone, and you ask them to do you a favour, more often than not they will vote it through. To me, you want to avoid getting into the detail because it's a relatively complex situation. If people want the detail, give them the newsletter I wrote and they can read till their heart's content. Once or twice I've had to speak to committee members who were lawyers to explain what's going on and why, because the reality is, and you can put your hand on your heart and say, this is not me. This is the banks, and everyone hates banks. And banks are difficult. And it's not, are you going to sell? And the answer to that is, well, and the one, got one next week where we are going to sell, and committee knows that, and that's all cool. What we've told them is, here's the reality of the situation. You're giving away something that is effectively worthless. What we're going to have by the ability to do that though is open up our buyer pool to anyone from any bank. Because at the moment we're restricted in the context of certain banks won't lend just because of this stupid provision, and if our buyer is with that bank then they go out of the loop. So we want to bring to you the best possible range of buyers, and we can only do that if we've got the best possible financeable agreement, and that's what this clause does. Otherwise, if you're there for the long term, the line is still the same in the context of we want to be able to have the best possible financing, and the best possible financing means this thing's taken out. So all of the banks are open to us. Because if it's not, we can only go to a couple of them. And then we're subject to whatever their policies are. So that will normally get it across the line. I suppose that's evident in terms of the only couple of them that we've lost. So yeah, but it absolutely needs to be done. So don't go waiting again until you've actually got the contract on foot, and then the buyer conditions finance approval to say we need Gallery V dealt with, because that then means a general meeting. There is no ability to do this stuff at committee level. General meetings at least probably 4 weeks notice now when you take into account the postage, let alone the time dealing with the body corporate and the lawyers and everything else. So to me, if you said to me today, Frank, we need a general meeting to sell, I'd say you've got to add 8 weeks to your program. And the uncertainty of it, because you don't know the outcome. You want to control the outcome. So to me, you control this outcome by auditing go and have a look at your management rights agreements, look at the termination provisions, and if they refer to insolvency, termination, liquidation, receivership, you're caught by Gallery V. Deal with that at your next general meeting. Relatively simple process, very well-worn path. It's not a secret ballot, so you can actually see which way people are voting. You can rustle up votes, which is better than top-ups, which I'll talk about next, and deal with it. Because there was talk at the time about the government will change the legislation and blah, blah, blah. No, they don't care. They've got 1,000 different things on their plate, and while this is important to us as an industry, it is just not even on their radar. So from my end, deal with it, take that off the list, and we're starting to absolutely get, and it's probably good, the brokers are now clearly asking people when they list, are you Gallery V compliant or not? Because I'm sending out variations we've done for clients in the last couple of years to say, yes, you're sweet. One tick off the list. One less thing you have to worry about in terms of selling. Now the next one, term. So again, probably some of these are good business practice, some of these are great from a sales perspective. Term or tenure, how long you've got on your agreements, is still crucially important in any sales process. So again, standard module, you've got a maximum of 10 years. Accommodation module, you've got a maximum of 25. From my end, you don't want to let a standard module agreement get to less than 8 years. Every 2 years you want to be topping it up. We've got one client on the sunny coast netting $1.5 million in the standard module. We do him every single year. In the accommodation module, you really don't want to get it less than 20. So you top it back up. Now this isn't like immediately fatal in the sense of anything, but from a financing perspective, your bank's going to be structuring your loan payments over the remaining term of your agreement, or probably up to 15 years, subject to whatever their policy is. If you've got shorter term, they will put you on P&I. And you don't want to be paying principal if you can avoid it. As much as it's a forced saving for some people, it's not tax effective, etc. And for me, it's not a matter of giving you financial advice. It's a matter of preserving for you the greatest flexibility you can possibly have when it comes to financing, and that comes with term. So you need to know how long you've got left when you need to top your agreement up. So from a sales perspective, it's critical. From a financing point of view, again, you get that knock on the door from a broker saying, hey, I've got the greatest buyer in history ready to go. They want to buy your building, but they need 20 years and you've only got 12. Then you're potentially off the general meeting to fix that again. So you want to be ahead of that curve. And probably the answer to this is exceedingly simple. No you term, so that's appalling typing from me, so that should be no your term. Know your plan to sell. If that's 18 months, that's 2 years, that's 2.5 years. So the way the legislation works is you can top your agreement up by up to 5 years once every body corporate financial year. If you want to ask for 5 years and 1 day, you've got to go and do a new agreement. So for me, a new agreement, which you can do as often as you like, is a completely different process to a top-up. We tend to get variations through relatively easily in terms of burying an existing agreement. If you want to go and talk to a committee about a new agreement, obviously term might be your driver, but what's then in the committee's drivers are, well, what are you doing? What are we paying you? What do you want to do about this? What are you going to do about these office hours? And it just opens the Pandora's box of whatever their wish list might be. If you fire in a request for a variation, which you've got the right to do come the end of every body corporate financial year, so every body corporate financial year finishes on one of the 12 months of the year, tied back to when the building first registered. The way the legislation works is if you get a motion into the body corporate manager before the end of that financial year, it's got to go on the agenda for the AGM exactly as it was submitted. And that AGM's then got to be held within 3 months, and that's when the committee's elected and so on and so forth. So you've got the right every year to lob one of these things in if you think the time is right. So the call for you is whether you think the time right. Where am I sitting in terms of term? What's my relationship with the owners? What's my relationship with the committee? What's my plans to sell in the next 12 months or refinance? And at that stage, you can then make the decision to do it. So what we do as part of any top-up now is include in that a Gallery V option, I suppose, where you get the choice about whether you're going to do Gallery V, whether you run the motions together, you run them separately or whatever. And where I've got to from a Gallery V and top-up side of things is you're going to get both or you're going to get none. It's very rare. If owners support you, they support you. And they'll support you on whatever you do, as much as we had one client who put up separate Gallery V and top-up motions last year, and we lost by 7-7. 7 votes for, 7 votes against, which means we didn't have a majority, so it didn't pass. So this year we got a bit more organised. I went down as power of attorney, so I was holding 15 votes. We won our variation motion by 30 votes to 7, which clearly showed there's 23 people that couldn't be bothered last year. And we won our Gallery V one by 18 to 10. So it's just, anyway, you never know. I think as, I think it might have been Paul Keating said, the only people you can trust in a ballot are the ones that say they're not going to vote for you. Everyone else is up in the air. And top-ups of agreements are secret ballots, so you don't know until the day. So anyway, back to this. So you've got the right to do this. Do not let it run down. So good business practice is having as long a term as possible, because as much as it's very rare to see a management rights agreement run down to 0, in theory that can happen. I can probably count on one hand the times I've seen it in the last 20 years, but you don't want that to be you. So, and it's a whole lot easier to have that conversation with the committee when the committee says, well, we're not going to renew your agreement. It's like, okay, well, I'll see you in 2040. Or I'll see you in 2028. Because you will outrun them. They don't have the grind that you've got to go the distance. But that makes sure you're on top of it. So there's a service, and I flog this incessantly. Everyone should use it, but I'm almost a little bit subjective about that. There's a flyer in there. So for free, we will remind you what you need to do and when you need to do it. We at the same time will offer you our services to do that, and if you don't take it up, that's okay. Because it's very easy to forget these things in the day-to-day of running your business. It really is. You drift along, everything's going well, and suddenly you've got 9 years to run. It's like, where the hell did that go? And really, that service that we offer, that reminder, came to me from a client who clearly didn't have debt funding. We put him into a standard module complex with 10 years. He rang me 9.5 years later and says, Frank, I've got 6 months to go, what do I do? So we urgently called EGMs, got him topped up, got all sorted. But if he had a militant committee, or someone that didn't like him in there, that could have been enormous carnage. So he now gets, and he's still there, no less than 8 years. It's time to go, let's go. And he does. It's just good business practice. So we can build that in, all the materials in those handouts, or just email me and I'll sort out what you need to do. But that again is making my job easier, because then I'm not dealing with general meetings halfway through an assignment. Because what happens when you need a top-up or you need Gallery V is you're going to your body corporate during the contract process, and at that stage you can't tell them you're not selling because you're under contract, saying, my buyer needs this. So what you're doing is asking your committee and your owners to give a favour to someone they have never met before. It's a hell of a lot easier to ask them to give that favour to you when they know you. So Justin, there's a whole separate seminar in terms of marketing to your owners, or your voters as someone called them to me the other day. You've got to be a bit political about these things, but being on top of that is just so important. Next one is this, and it's a straight follow on from that. So what we have is 10 years or 25 years, or 18 years or 12, or whatever it might be. Inside each of those agreements, that term can be broken up into an initial term and any number of options. So the traditional approach might be a 5 + 5. So you get a 5-year term and a 5-year option. From a lending perspective, provided that option's exercisable at your discretion and in your favour and you've just got to tick the box, for all intents and purposes that's a 10-year agreement. But what needs to happen, more often than not, is once that first 5 years comes up, you need to physically do something to trigger the second 5 years. That's given notice to your body corporate that you've exercised the option. Then that 5 years comes into existence and away you go. So this is a concept that still gets misunderstood quite a bit. So when I was talking about see you in 2028, that's provided we exercise whatever options we've got in those agreements. If we don't exercise our options, the agreements come to an end. And that is, again, brutal from a valuation perspective. So you've got to be on top of these things. So I did the sport this morning. Again, this has come out of bitter experience for clients not exercising options. I think we're the only ones that do it, but I don't know how other people do it. When you buy through us, we build you into our system, you get a reminder of what you need to do and when. Now this has only been going for a couple of years, so for anyone who's done that recently, you're in the machine. For anyone who we've acted for some time ago, email me and I'll make sure you're in the machine. I think I've got everyone, but I'm not sure. And if you're not in the machine, I'm very happy to put you in the machine on the same basis we do with the variations in terms of I will remind you, and sometimes we have clients go and do it themselves. That's all cool. But if you don't, those agreements come to an end. And that is mission critical in a management rights sense. So again, in terms of what you're going to do when you finish out of here, you're going to go and look at your management rights agreements. You perhaps might even dig out your due diligence when you purchased. And if you're not sure, you're going to flick them through to me with an email and ask me to confirm, and I do that for nothing. Simple. So yeah, it's an absolute no-brainer. So do that. Simple. So that's, yeah, that concepts get there. And again, the problem with options is that they can be 5-10 years in advance. You might buy a business in 2014, the option's due next year. You've forgotten completely about that because you're happy running and dealing with your day-to-day existence, which is what you should be doing. I actually went through, we've got a automated process and we've got a manual backup for it because obviously we don't want to miss dates either. We've got 37 options for clients to exercise next year in the system already. And who knows how many will come out over the next 12 months. So, and I can guarantee you, if I wasn't reminding people, half of those would be forgotten. So it's just so important. Now the next thing we're getting, and I've left a couple of banks off this, but that's not to be offensive, they all still lend, is delays with banks. So what we've had from an industry perspective is basically two of the biggest valuers have departed the scene. So if you've got a finance approval subject to evaluation now, there are substantial delays. We've got APRA belting the daylights out of the banks across everything. So this isn't a management rights specific issue. This is a bank lending issue full stop. And you've only got to read the front page of the Fin or the Australian every day to see what happened at the Royal Commission the day before in terms of what the banks are getting smashed for now. So they're all being extremely cautious, extremely detailed and extremely slow. So you used to be able to go back 5 years, actually probably pre-GFC to be fair, we're back 10 years, which is a long time ago now. 28-day finance clauses were fine, 60-day settlements would be tight, but you could do it. Now, I think a 35-day finance clause is too tight, 42 is more realistic, and a 90-day settlement is tight-ish, because there's part B of this, which is the body corporate approval. So for me, this is something you can't manage. You're in control of the figures. You can make sure your appointments are what they are and they're all 100% right. Hopefully you've engaged the right lawyer on the legal purchase to make sure the due diligence stuff is sorted in terms of a legal sense. From a finance perspective, you've got to rely on the broker putting the deal together or your buyer to not have told you fibs about how much money they're going to be able to get, because that's the bit of trust you're going to put in them. If they're spending $1.5 million to buy your business, they're not doing that to waste their time in effect. Because by the time a buyer spends 6 weeks getting to finance approval, they've stopped looking, they've spent all that time looking, they've found the one they wanted, they've paid money for legals, they've paid money for figures, they're committed to the deal, and the fact they can't get it across the line for whatever reason is the issue. So for me, first thing, be ready to extend finance approval dates, because that's not in the control of the buyer, that's in control of the bank. And if it gets ridiculous, ask questions. So we had one that was signed up almost Christmas Eve last year that went unconditional a week ago on finance. So we had some due diligence issues along the way, but that got sorted. And it got to the stage where another week, and where I got to, again, part of that management rights mafia is client was saying, well, you know, I want to terminate. It's like, well, hold. The reality is that buyer's committed. They've spent 4 months getting to here. They've spent a bucket load of money. They have paid for evaluation. It's not that they're wasting their time for the sake of wasting their time. So to me, the issue is, why is it slow? So what I asked the seller's lawyer if I could talk to the financier, because again, we all know each other. They said, sure. I rang the financier. I got the reasons why. They all made complete and utter sense. Went back to the client and said, calm the farm. Because the reality is, if he terminated then, he's still probably 8 weeks away from being in the same position that he was then in terms of having a buyer committed to the deal, trying to get unconditional on finance. So the only reason to terminate is if the buyer's definitely not getting there. And then look, some people from a buy side might need to sell their house, but don't tell you they need to sell their house and then put a long-term finance clause in. So that's the stuff you need to get to the bottom of. If you're taking a punt on their unrealistic expectations in Sydney, then you're wasting your time as well. So if it was they don't have the equity until they sell and this is where they're at, blah, 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 that to me is a different story from we've got valuation delays, we had an issue with their P&L, they hadn't filed their tax returns until last week, or whatever it might be. So just be ready for that one. And of course that then means that it's probably brave to book an overseas holiday for the day after you're supposed to settle when you sign the contract. I've lost count of those conversations as well. Everyone's ready to go. Or at least get a flexi fare so you can dust it and do booking.com so you can cancel them. That will blow you out at the back end potentially, because if we've got an 8-week finance time frame and we've allowed 90 days for settlement, that's only 4 weeks for body corporate approval, and who knows what will happen then. So just be a little bit cautious from your end about booking those holidays. But it really is, this is one of rolling with the punches. Again, be alert, not alarmed, but that is happening a lot. We basically get finance extensions on every single deal. Now this is also new. So you go back, I suppose I started my legal career in January 1992. Down here is a little 5-year article clerk. And at that stage, I was doing some management rights stuff, but obviously at a very limited level. At that stage, we had the Auctioneers and Agents Act. There's probably some people in the room that might remember this, and I won't throw you under the bus, Keith, but maybe you're one of them. Where the licence, to get a licence, you went to fair trading and you ticked boxes. Yes or no. That was the extent of the qualifications you required. Body corporate assignments, when they'd consent to the assignment of agreements, usually wouldn't have lawyers involved, would occasionally have meetings, everything would just be signed and away you'd go. We moved to today, and that's changed a lot. Obviously from a licensing perspective, all of you have been through that, proper qualifications now. Fair trading still the same pain in the backside that they've always been in terms of getting a licence before settlement, but you've handled them right, they're okay. What we've absolutely seen though in the last couple of years is basically every body corporate will get legal advice on the assignment of the management rights agreements. And to be fair, from a committee perspective, and the strata managers drive it, and this is part of my business as well, is they've been asked to sign legal documents, so they're entitled to get legal advice. That's at your expense. That's always been there. But what's happened over the last couple of years is there's been a new breed of assignment expert roll in to do one of two things. First thing is training, and the second thing is assessment. So where it sits from a legal perspective is a body corporate cannot unreasonably withhold consent to an assignment, which means they can't say no unless there's good grounds to say no. So if you've got a criminal conviction for trust account fraud, they're absolutely entitled to say no. As much as I've had clients, one client in particular who did 3 years in the bin for cocaine dealing got approved after being disclosed. But anyway, it wasn't financial fraud, so that's all okay. But what we're seeing a lot more is bodies corporates taking this process a hell of a lot more seriously. And sometimes it's driven by the strata managers, sometimes it's driven by the committee, sometimes it's driven by their relationship with you, but either way, it is where it is. So at law, a body corporate's entitled to have from the buyer details of their competence, qualifications, experience, training, financial standing, and so on. Whether your committee on an assignment asks for all of that is really dependent on them, their advisors, their previous experiences, and so on. But there's a lot more of them doing it. So from a training perspective, and this is the first one to appear, and you'll find this, and to me this isn't necessarily bad things. A couple of people running around providing sort of short form training courses, 2 or 3 days, to buyers in terms of 100-point checklists for handovers and all this sort of stuff. What you'll find is a body corporate, particularly if they haven't necessarily been as happy with you as they could be, maybe saying, what training is this buyer getting? And there's a breed of expert out there now that will come along and do a couple of days with them in a formal training sense, not TAFE qualified or anything, do it on site, walk them through what they need to do, etc., etc. And to me, that's not necessarily a bad thing. Clean set of eyes, and it ticks the box on the training from a formal perspective. The other thing that's happening, and this is absolutely more recent, is committees are in effect getting advice, not necessarily legal advice, but advice from external third parties who assess the ability of the buyer against what they're needed to do under the Act, their competence, their qualifications, their experience and so on. And some of this is getting a little bit out of hand in terms of what people are charging, what they're doing, the process itself, and how it works. And even we had one the other day, we were acting for the seller and got pinned $3.5 grand for this assessment. And it's a seller's cost is the short version. It's very hard to pass it on to a buyer. Under the management rights agreements and under the contract, you're responsible for procuring the body corporate's consent to the assignment. So if that's what they want, that's ultimately where it needs to get to. And unfortunately, at the death of the matter, when you're 90 days in, you're not going to drop the sale for $3.5 grand. But anyway, so we're back to this one. We have the assessment from the buyer. The body corporate lawyer sends it through to me. The buyer's got a 65% rating. I said, you beauty. You know, back when I was at uni, 50% was a pass, 47% a conceded pass, we're done. No, Frank, they need 80%. So what complete crap. So we had a whopping argument and they backed down, but this is the sort of stuff that we're starting to have to deal with now. So again, this is one of those ones to be alert, not alarmed with. So first thing is that top one is find the right buyer. And this is incumbent on everyone really, and this is the brokers as well. Some people are not suited for this industry. If you want to shoehorn someone that's not suited to this industry into your business, be ready for it to be a bit more of a rocky road than it would have been 10 years ago. That's not to say we won't get there, but it can be more difficult. But obviously, the better presented your buyer, the more professional qualifications they've got or otherwise, not professional qualifications, the more they've got experience that can be applied to the management rights industry, the better off you're going to be. Interestingly though, whether that's former management rights experience, I was running through with my team last week about the management rights refusals we've had in terms of committees refusing to consent to assignments. Every single one of them was a previous management rights owner, where somehow the body corporate asked for references from the previous committee or contact details, and some of those were brutal. One of them, we had a client buying 2 big ones in Brisbane that owned a small one at Sunnybank, and randomly the chair people knew each other. So one reaches out to the other because he sees you on this complex, so what do you reckon about so-and-so? Oh, sit tight, I'll send you some emails. And so back came the abusive emails from the manager to the committee, back came the remedial action notices they've been issuing for the last 12 months, bang, deal dead. So that's an interesting one in terms of applied experience. And I'm sure there's the right buyers out there, but just be cautious with that. You know, I had one client years ago, very experienced and probably by bitter experience, he wouldn't sign a contract unless he'd seen the buyer's resume, references and the whole box of dice. Because I'm not putting forward someone that I don't think this committee's going to wear. You need to be in that same boat. So that's not to say that they're going to say no. That's just one of those things that need to go into the mix when you're looking at someone to sell to. So if you're getting knocked over in the rush and you've got 15 buyers lined up, happy days, be as picky as you like. If you've only got one buyer, then that might be what you have to go with. But just be aware of that. And particularly how your relationship is with them. Now the next thing, again, people have relationships, people use other people regularly. So if you're getting to the selling stage, and part of what we're doing when we're acting for people selling now is once we get across the line on legal due diligence, we talk to our clients about the approval process in terms of this is what's likely to happen, this is what these people run with, this is how we need to try to take control of where they go. Now the committee ultimately is going to pick who they want. The strata manager might be strong-willed or otherwise, but I mean I know which strata managers refer to which lawyers and which lawyers refer to which consultants, and that's start to be part of that mix, and they might be some of the problem children. So the way to deal with it is to try to manage that process at that stage. That's not to say you're actually going to get there, and clearly if your committee and your strata manager hate you, they're going to do whatever they want. If they've got a relationship with you, then we might be able to shuffle them to someone that's still going to do what needs to be done, but not cause the enormous amount of grief on the way through. So again, that is just be alert, not alarmed again. And the last one, if it'll go, space, there we go. Now she could hardly cause you grief, but you would be surprised. The due diligence process when you buy a management rights agreement is very rigorous, or a management rights business. The accountant, as I've pointed out, tears through things. The bank's going to get delays, valuations, whatever they want. The legal due diligence is absolutely going to include a body corporate records inspection and minutes and fights. So for me, this is one of those ones where if you are in a blue with your body corporate, you need to control the message in terms of what the buyer's actually getting. Because again, back to that first slide, trust. If you've told the buyer it's an oasis of peace and calm and harmony, and it turns out you got hit with 4 remedial action notices 2 weeks ago, that's not going to go down all that well. So to me, it's a matter of controlling that message and not control it, but managing the message. So if you are in a blue with your body corporate, and that's one of the reasons you're selling, then why? Is it personality issues? Is it arguments over particular duties? Is it you've been there too long and you're tired and you're ready to go? And believe me, I have that with clients. You know, I don't know what the average turnover is. It's certainly probably more than 2 years. Get the odd client that goes 10, 12, even 15. And they clearly learnt how to get away, manage it and all that sort of stuff. But people do get tired. Committees come and go. It might be, you know, some particular dictatorial person that's driving a particular agenda and this is how we're going to deal with him or her. But either way, it's a matter of that not being a surprise. So again, there's no hard and fast rule on this one. I can tell you to go and make sure you've got every single letting appointment in place and that's a no-brainer. You know what you need to do and you'll do it. In terms of managing, selling a business that has issues in the minutes, it's a matter of horses for courses and coming up with a particular strategy for it at that point in time based on what the circumstances actually are. I think the takeaway is don't hide it because it will come up. I'll space that. Yeah, so solve them or manage them. And again, this is a question for your broker as well. Like you don't want to, you know, the first time the buyer comes in, say, I've got the biggest bunch of idiots on the committee known to man, that's going to turn them off. That's not what they need to hear. But you do need to manage that on the way through. So again, the right broker or the right handling of it, but it's just got to be managed because that is a surprise that people do not like. And yeah, there's some things, you know, if something's 18 months, 2 years old, it's really academic, that's done and dusted. If something's 2 or 3 weeks old, then that's current. We need to deal with it. And from a sale perspective, it's not uncommon in those sort of circumstances where the relationship has absolutely turned to custard, is to produce the buyer to the committee before we go through any of the other due diligence processes. And that's particularly the case where we might need a top up to sell. So I've done that, it happens. It's not a regular occurrence, but it happens and it's one way to deal with it. When the committee says, you know what, this isn't working, it's time for you to go. We're happy to let you go. We will give you 5 years, but you bring us the buyer before you sign a contract. And then you manage the process that way. And that's not even necessarily the full legal due diligence with deeds of assignment and that sort of stuff. That's just meet the buyer, have a meeting, make sure we don't have two heads, make sure we like each other and can get on, and then we go sign the contract and go through everything else, knowing that that's what's going to happen. And at that stage, if you need a top up on the way through, that's then got the endorsement of the committee, which makes the EGM process happier and all that sort of stuff. So there's ways and means to deal with most things, but really this one is don't just leave it lie. Address it. Control the message. And that really, ladies and gentlemen, is the thing there. For me, those are probably the list of the biggest issues we've got right now. And that's not to say there's other bits and pieces that won't come up on the way through, they will. But if you do most of those, if you've got your term right, your options right, your letting appointments under control, no fights with your body corporate, your sale will be a hell of a lot easier. And that is a hell of a lot less stressful for you on the way through. So that's it for me. And now we have questions.
All right. So just to make sure that any questions get heard clearly on the video, I've got the microphone to hand out. So not often do you get someone the quality of Frank at your disposal.
Free legal advice, despite Justin's disclaimer at the start.
And also, your question, which you might be feeling a bit shy for asking, someone else right next to you might be feeling a bit shy for asking. So we don't have any silly questions. Let's see how we can all learn. So questions, I'll take them now.
Frank, at what stage do you speak to the body corporate manager and the committee members if you are proposing to sell?
Cool. So that depends on your relationship with them. So for me, part of our sale process is when we sign a contract, the first touch base with the client is be aware that the buyer is going to go and conduct a body corporate records inspection. So some of the strata managers are live to the issue in terms of they keep an eye on which lot is the manager's lot and will know. Some are just off dealing with all their committee meetings and don't care. So to me, the strata manager one depends a little bit on that, depends on your relationship with them and where you sit. Most of them, in my experience, if you give them a quiet, hey, we've just signed a contract, wouldn't mind if you keep it quiet, we'll be in touch in due course when we know where it's getting, don't want to spook the horses, etc. Most of them will respect that. From a committee perspective, it's different again, comes back to your personal relationship. So in a legal vacuum, you're not obliged to tell them until you go unconditional. Because at that stage, it's only when you need to ask them to consent to the assignment do they need to know. But what I absolutely do know is that if you've got a relationship with them that's relatively friendly and you haven't told them, some of them can get their noses out of joint. If, well, why didn't you let us know? Okay. You know, and I have had clients who have outright told committees, no, you're not selling, and then they get the bloody listing from a portal slid under their door, and it's like, you're lying to us.
Yeah.
So, you know, and it's more and more evident as marketing gets better and stuff gets online. You can see buildings, you see names, and we're even starting to see more buildings advertised by name. So if you're going to go out, you know, the agents will say you can't sell a secret. So if you're going to go out and sell it openly, I'd bring them into the tent early and say, this is what we're trying to do. This is why. Obviously, it's a better sell if you've been there 5, 6, 7 years. If you've been there 18 months, there might be another reason. You know, it's not working for whatever reason. We will let you know what's going on. We won't waste your time until we found someone who's the right buyer, and even that's controlling the message, you know? Because just the reality is that there's so much information available out there online, they tend to know, but you don't want to lie to them.
And at what stage would you let the owners in your letting pool know?
Again, that's a relationship thing. I think probably a lot of them, we do serve up to clients goodbye letters. Here's a letter you can say goodbye. And the reality is that if all those letting appointments are in place and assignable, they're all going to go automatically across to the buyer anyway. So to me, that's just a relationship management exercise in terms of been great dealing with you. You might shoot out a little email, but to me, probably not until you know that you're going to get body corporate approval. Because at that stage, it's all academic, and you don't want to spook those horses in terms of, well, if you're selling, what are we going to do? Like, well, we've sold and it's all good. Mm-hmm. That would be my take.
Okay, thank you.
No worries.
There. Hi, Frank.
All right, bring my water out here.
Yeah, it doesn't. It's
Great.
Not working. Hi, Frank. You told the story.
No, you
about,
talking to that and shout, mate. I'll hear you.
Yeah.
You just hold that up to your mouth. It's for the video camera.
All right. Okay. You told a story about a voting process that was lost and was 7-7.
Yep.
And that lost, and then you went back to the drawing board. Could you just briefly tell that again? I think you got proxies or...
Yeah, so...
For those who couldn't hear, that it was coming back to the vote that Frank mentioned during his presentation that lost 7-7, and just to elaborate on
So I'll let you all in on a big secret. So there's what the BCCM Act, so you go back to BUGTA, Building Units and Group Titles Act, which is the legislation we had up until 1997. Under that, people could appoint, and I'll swap sides of the room, sorry to muck you around, Scott. Under that, you could appoint people to represent you and vote on whatever you liked. Under BCCM, they in theory shut that down. So you can vote in person, you can only hold a certain number of proxies, you can only vote for proxy on certain types of motions, like for example, not management rights motions, but a big gap in the Act is that you can appoint someone as your power of attorney to vote for you on anything. So, and you can make that power of attorney limited to whatever it might be. So I've got a wonderful little sideline going where I get appointed as power of attorney for lot owners to go along and smash motions through. So, and that's not, there's nothing untoward about that at all, because the reality is that particularly on a secret ballot, which at this point in time we can only do under the legislation, which is bloody post, and post guarantees 7 days to someone, guarantees 7 days back, let alone the time frame they've got to actually fill the thing in. A lot of people that don't reside on site, or particularly offshore, don't have the ability to exercise a vote on a secret ballot because they just don't get the paperwork. So if you've got investor owners, they can appoint someone who's not you as manager as their power of attorney to go along to the general meeting, fill in the secret ballot and vote for them. So the biggest one I've had so far was 80 people appointed me as their power of attorney to go along and vote our top-up through, vote our gallery B through and smash the committee out, which with 80 votes you tend to be able to do. So, but it becomes really important. So if you go back to that 7-7, the reality of that was that we had the support of people, it's just that they didn't vote or couldn't be bothered to vote, or our client didn't chase them up hard enough, because the one thing I can guarantee you is people will say they will do something and for whatever reason life gets in the way and they don't do it. So here's a power of attorney, sign it and send it back, you're appointing our lawyer or some other stray, and you go along to the meeting, you get the ballot papers from the returning officer, you fill them in and you vote. So that's a way to get people who otherwise wouldn't vote to vote.
Okay, next question.
Hi, I'm Gail. I've got an accommodation management rights.
We need a...
I've got...
Oh, you've got it? Oh, cool.
Hello, hello. Thank you. I've got an accommodation management rights, and I've only been in the industry for about 14, 15 months. When's the best time to apply for a top-up if you've got, say, 14 years or, say, 13 years left on the tenor? When's the best time to top
Easy.
up? And we've got an AGM coming up very shortly.
Now. So I think probably the best time for me is when your relationship is right with your owners, and to me, your relationship is right when people aren't making any noise. Unless you're under attack, 99 times out of 100, you'll get the top up. It'll slide through uncontested, no one will know the difference. And even we lobbed one in yesterday for a client where we think we had a couple of twitchy committee members, but we fired it in because we're going to flush them out in terms of where they stand. So, like for me, a top-up and gallery B is like a $2,000 process or so. So it's not the end of the world. We can recycle the documents next year for minimal cost if we lose. But what it does is it flushes out where people actually stand. So if you've got 13 years, to me, sooner rather than later to get you to 18, and then next year you'd think about whether you do it again to get you back to probably at that stage 22, and then effectively you're done. Or you might park it for 12 months, subject to how it goes, and then go to 21 years. But the further out you go, the more secure you are. To me, it's that simple. And you're probably going to have a conversation, and if you haven't borrowed, that's great. But when you start to get inside 15 years, if you've been there 14 months, one of the other big things that not a lot of people understand is that from a residential loan perspective, loan terms are indefinite. From a commercial loan perspective, every 2 or 3 years, you have the wonderful conversation with your bank about, okay, where are your letting appointments? Where's your revenue? We might need evaluation, so on and so forth. If you've got 12 years left to run, that's where the bank might say, oh, well, now it's principal and interest time. So that $1 million you borrowed, you've got to pay that $1 million back now over the next 12 years plus your interest payments. So if you've topped your term back up to 2018, that normally removes that conversation. Yeah.
So for the video, is that the solicitor's job or the accountant's? And Frank's saying the solicitor's.
Oh.
Yep.
Frank, mine's regarding the clawback. I'm a buyer,
Yep.
and I'm coming in to purchase
Yep.
management rights holiday units, and one of the units is for sale, hasn't sold. What would you be advising me as a buyer?
Cool. So the question relates to clawbacks in a holiday context when a unit's on the market. So I suppose it's in the letting pool? It is in the letting pool. Cool. From a letting pool perspective in holiday, it's a slightly different story as well with clawbacks, because the only time the income goes missing is at peak occupancy. So that typical coming up with a number for a clawback is really difficult. But the other thing is with management rights, the biggest commercial risk is the loss of units from the rental pool. That happens. So, and to be honest, I think when, back to another John Howard story, when the first home owners grant rolled in 2000, letting pools got decimated because all these first home buyers were getting their $7,000 charging in. 3 years later, they all went off to the mines and did whatever they did, and the letting pools went back up to where they were. So in that period of time, it was a little bit rocky. But by and large, most letting pools stay the same. So my advice to you would be exactly that in terms of this is where it is. The reality is they come and go. Who knows where it might actually finish. You might pick one up, you might not. But coming up with the number in a holiday context is really difficult for a clawback, because it really is if the things, you know, and even then, the occupancy might be running at 70%, but that's 50 versus 100 at Christmas. So what we're effectively going to be losing is potentially the Christmas income, and that might be it. So what's that actually worth? That's the, you know, you're roughly 50% of whatever that revenue is. It's not really potentially the same as in a permanent, where you lose a permanent unit, it's gone. There's no way to build it back up. But I'd push it back to you and say, that's your call. There's the considerations. And part of it also is price. You know, it's like a function of risk and return. Like if you're buying it at 2 times, who cares? Just do the deal. If you're buying it at 9 times, then hang on a minute, we need to have a conversation. So, but I know you'll be somewhere in the middle, but that's all part of that ebb and flow of whatever the commercial parameters are for the thing.
Next question.
Hi Frank, my name is Sunny. I just want to extend the question about top-up, because according to the new legislation, you know, for some of the managers, they don't have a residential property on site. So to exercise, you know, the top-up.
Cool. So how do you get a motion on the agenda when you don't own a unit?
Yeah.
Cool. What you need to do is either get the support of the committee to do it, or find a friendly lot owner that you manage to lob it in for you. So again, part of our process is, if you don't own a unit, here's the consent form that you can get an owner to sign, and then we lodge it on their and your behalf before the end of financial year. But you don't, as a service contractor alone, you're a bit like us. Like if we're acting for a body corporate, we've got no right to get a motion on the agenda. You're the same as a caretaker, but what you need to do is find a supporter. So normally I'd suggest that you start by talking to the committee to say, this is what I'd like to do and this is why. And if that's not necessarily positive, A, you can reconsider whether you do it, or B, they might agree to do it, or you just go find a lot owner to do it. And lot owners have that right.
Next question up the front here.
Yeah, I just would like to call back to the, you know, you want the lot owners vote for the seller, but you are the seller's lawyer, and then you act like 80 lots owners representative. So is there any conflict of interest?
Can you paraphrase the question?
No, sorry, I've missed the question.
I mean that you are the seller's lawyer, right?
Yep.
And then you also act for all the lot owner to try to vote for the
top-ups and things. Oh, well, I suppose, to me, if I'm acting for a manager to go to a meeting with powers of attorney to vote, then I'm acting for the manager.
Yeah.
But I'm also, and part of the process in terms of the power of attorney is that clearly the owners aren't just going to sign a document that's put in front of them. It's explained to them what it is. And so what we give our clients to do it is, here's a letter to the owners to explain what's going on. So the letter will go to Justin. Hi Justin, you can't get to the general meeting. I know you're a supporter of ours. Here's a power of attorney to appoint our lawyer, Frank, to go to the general meeting to vote just on the motion relating to the top-up, and it'd be great if you could sign and send that back. And they do, and I've got it. The owner, Justin, knows that I'm voting in favour, so there's no conflict there. Justin's got the right to revoke that power of attorney up until the minute before the meeting if he feels uncomfortable with it, but the reality is people don't sign it unless they're comfortable. So I've never had anyone contact me yet with a problem about it. So
I think what was interesting for me about that power of attorney was how specific that power of attorney could be made.
Yeah.
Whereas I'm quite familiar with powers of attorney. You know, I signed one for mum. You know, if something happens, you know, I'm mum's power of attorney. It's very broad. But in this instance, Frank's referring to something that's incredibly specific. So another question here up the front.
And I suppose we can just we can tailor the powers of attorney to fit whatever the circumstances are. It can be specifically for motion 12 on the AGM for 2018. It can be for the committee election and motion 13 at any general meeting during the next year. It can be for anything for the next 3 years. It's really what is necessary. So to me, the more tighter you limit it, the more chance you've got of getting support.
So is it not any conflict of interest? Anyone
No.
can just...
No, I'm acting for the manager with the support of lot owners that support them.
Hi. In a case you are appointed by a body corporate and instructed that we don't want to change on the manager, then what advice?
They don't want to consent to the assignment.
Right. So
Yeah, well,
what advice we will give the committee?
So the question is, what happens if we've been engaged by a body corporate with instructions that we don't want to consent to the assignment? My response to them is going to be, you don't have a choice. You can't unreasonably withhold consent to the assignment. So, and that's not going to say they're going to listen to me. I mean, I can give and I've had clients not do what I suggest they should do in the past, and that will happen in the future. What I make sure I do is that I cover my backside in terms of this is the advice I'm giving you. So what it would get to the stage, and I haven't, we had one, probably a twisty one a little while back where a body corporate, it's a longish story, but I will carve it to the guts of it, where the developer was selling management rights, buyer was buying, committee was happy with the buyer, but they wanted to cause grief to the developer. Building defects, all that sort of stuff. So it got to the stage where we said to the committee is, if you continue to do this, you are going to run the risk of bump, 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 which is the buyer terminated and walked away, you're exposing the body corporate to damages on resale, we're telling you you're acting unreasonably, etc., etc., etc. And that ended up settling, but it might come to the stage where they refuse to listen to me, in which case I'll sack them as a client. But if there's grounds to say no, then there's grounds to say no. So a committee can't automatically just say no. They've got to go through the process, they've got to be able to justify their decisions, and they've got to be able to put their hand on their heart at the end of the day and say, well, this is why we refused it. And so to me, from a body corporate perspective, saying no on an assignment is a very, very serious decision, because if they're actually wrong, it exposes the body corporate to damages. Because if you've sold your business for $1 million and the body corporate says no to someone that should buy it, and you later go and sell it for 800, the body corporate's in the frame for the 200 difference. So that's a very big decision. So yeah, but again, advice is advice. Sometimes clients don't listen to it. As much as I'm telling you, all use our service today. But yeah.
So the 65 and 80, you mentioned that the people only got 65. How can they get that 65 and they determine me to be 80? Like
I'll grab you guys after. I think there's a couple of questions.
Yeah, hello Frank.
Steve?
Back to the proxy issue again. Can you be appointed a proxy for a new caretaker agreement and with a secret ballot?
I can be appointed power of attorney for anything. Secret ballots, new agreements, variations, committee votes, every single thing on an agenda. And the rationale for that is giving people the ability to be represented when they might otherwise not be able to get there.
Hi Frank, Ros. With the proxy forms, can we write to you and say, can you send us those forms specific to a particular thing? Can you
the power of
send
attorney,
us a template?
I mean, that's a paid gig, but yes.
Yeah, the power of attorney forms, sorry. Yep.
Absolutely.
Good, thank you.
Hello. Regarding the assignment questions, you know, at the BC committee make a decision, say want to assessment for the coming manager. So who will pay the assessment fee? The buyer or
ultimately
the
it comes down. So I suppose there's in terms of who pays all of these additional fees that we're seeing on assignments, the short version where I get to is it's normally a seller cost. So there's two arguments. The one is that from a body corporate perspective, they're entitled to be satisfied about the bona fides of the buyer and their ability to do all the things that they should be able to do. If they require comfort around that, it's definitely not their issue, it's an issue for the parties. And then between seller and buyer, the buyer's view is always going to be, well, I've got the ability to do it, it's just the body corporate being difficult, so I shouldn't be paying the cost for this. And from a seller's perspective, it's really incumbent on you to prove to the reasonable satisfaction of the body corporate that the buyer can do the job. So the short version is it normally comes back to you as the seller. Occasionally we see the cost split, but normally it's a seller cost.
So normally it's sell.
And that's not well, in a vacuum it's a seller cost, but commercially it also normally finishes that way.
So the training fee is different, is it? If training?
Well, no, training fee is the same. Because what the body corporate's saying in terms of we want some official training here is that we don't trust you to do it. So we don't think you've got the ability to train the buyer, so we want a third party to provide the training that you're required to do under the contract.
Okay.
And a condition of our approval is that you pay the fees for that.
So normally sale need
yes.
to do this. Anyway, thank you.
So is it, sorry, piggyback on that, is it still liable to do the 14-day handover?
Well, yeah, so the training itself, the traditional approach is 7 days before and 7 days after. And subject to what the training actually is, we had one the other day where the body corporate conditioned the approval on the basis that the seller will be available by phone for the next 6 months. Fine. But the training programs I've seen, and particularly the short form ones as opposed to formal courses, are really the training person will come on site with you for a couple of days and then you're done. And they'll report back to the body corporate and say it's done, we're sweet, we've ticked off the 100 items, done. And I don't think that's a bad thing, to be honest.
A question in the middle here.
So are you saying that there are people out there that make a business of going around training people when they're going to take over a complex?
Yes.
And if so, do we as sellers have the right to find a cheaper one?
Well, yeah, and I suppose the same...
It's like panel beating, you
yeah,
know, you don't want to pay the top price that the body corporate want.
Most of the training people are, to me, fairly priced. There's not much difference between them. It's just that assessment stuff that seems to be getting a little bit skew-if. But when it comes back to being able to pick and choose who the body corporate engages, you don't have the right. So I heard this conversation sometimes with brokers particularly in terms of, we don't want this lawyer on the job. Why is the body corporate engaging that lawyer and the seller having to pay all those extortionate fees, etc, etc, etc? And it's like, well, that's just the way it works. Yeah, the body corporate's entitled to pick who it wants. If it's got the right to recover costs from parties, then that's its right. End of story.
Question here at the front.
Yep.
Oh, Frank, I've just had a contract fall over. So what it stems from is this 20 years. So the Chinese, a lot of Chinese are buying management rights,
Yep.
and they have 20 years in their head. If you
Yep.
don't have 20 years,
Yep. How long have you got?
I've got 14 and a half.
Right.
So I had an EGM of the committee. I've got a body corporate manager who have basically said, I can't vote, but if we put this out to a vote, we will be advising the owners not to vote on it.
Okay.
So, and at a cost of $5,500. So obviously didn't meet the first condition, the buyers walked away.
Yep.
So 2 parts, how do I get past this now? I've got an AGM coming up in October, so obviously I'm going to be
So your end of
applying
financial year will then be 31 July?
Yes.
Cool. You need to set in place a battle plan now to deal with it. So where it gets to is committees are within their rights to communicate with owners about what they think owners could and should be doing. So committees are entitled to say, we recommend you vote no. You are also entitled to say, I want you to vote yes and this is why, and then it's a battle of wills. So to me, what you need to do is, obviously 31 July is your drop dead date. I would get all your paperwork ready now. I wouldn't put it in until 4:30 on the 31st, and I'll be starting to map out a battle plan in terms of who are my owners, who are my supporters, who are my detractors, who are my don't knows, what do I need to do to get this across the line and go hard. And that's then a relationship exercise. So you can tick obviously the detractors include the committee. Hopefully all of your supporters are the investor owners, and the key thing is going to be trying to get them to vote and make sure they actually do send back in their paper, and it's just on probably the 31st of October you'll know. But you've got time.
So my other question then is, you talked about a top-up being 5 years, but
Yes.
5 years in 1 day is changing the agreement.
Yes. So to
we
me,
can only go for a top-up of 5
Yeah, so
years
you'll
to be
be-
voted at an AGM.
You'll be 19 and a half. And to me, what I say to clients in terms of term, obviously the longer the better, but there are some people that will only buy a business that's got 25 years to run, for example. That's very rarefied air, because that, you know, within 6 months, no business has 25 years to run.
Mine was only a 20-year agreement to start with.
Well, you can
It was
go
never
back to
a
25 with that. So one misconception out there is you can't go past what it originally started. You absolutely can. But so some people won't touch it if it's 25. If that's the case, so be it. You know, some people want 20, some people want 15, but standard module businesses sell all the time with no more than 10. So to me, it's a matter of finding the buyer that fits your particular circumstances. Obviously 19 and a half to me is not 20, and obviously that buyer is gone, but there'll be, to me, it'll be interesting to sort of do the numbers, not that I've got them, but very rare we transact a pure 25-year agreement. There's lots of 18s and 12s and 15s and whatever, and that's purely, and at the end of the day, a function of price. Everything will sell, it's just a function of at what price.
So taking it to a vote of the AGM as opposed to calling an EGM is not a cost to me, because
Correct.
I was quoted $5,500.
Correct. So once you put a motion in for the AGM, it's got to go on that agenda regardless. So sometimes the strata managers afterwards will try to send you an invoice for the returning officer and that sort of stuff. No, go away. That's the same as any other owner can put a motion on. They're not entitled to recover the costs from it from you. As this is the body corporate democracy we live in, it's on the agenda. So to me, if you're there, I'd cool your jets for a minute, suck it up for another 6 months, but get that plan in place to get through it. Cool. See, winner from today already.
Yeah, Frank, I'm in the position where I'm going to market this year to sell. I'm also in the position at the moment the body corporate have decided they want to totally review my contract and look at a increase in remuneration.
Bingo. Yep.
So, yeah, and they initiated it, which was fine. Two questions. I can go to now ask for 25 years on that contract. Is that correct, what you were saying?
If you're in the accommodation module, yes.
Yes, I am. Okay, and the next one is, I suppose it relates to clawing forward. Obviously, and I've been told the remuneration increase could be in the tens of thousands. Can that be then projected forward in my sales figures?
Absolutely. The basis on which you sell is completely up to you. So, and it's not uncommon to see verification clauses refer to a number, including the current remuneration. So for me, that's just a function of when you go to market, this is the basis on which you're going. And the buyer's accountant needs to know that they've got to project what the remuneration is going to be for the next 12 months. And that's a pretty easy thing to do because that's locked and loaded. There's no ifs, buts or maybes. So but from a sale perspective, I definitely have that agreement sorted, resolved, entered into, and then go to market with it from there, because then there's no uncertainty about it.
Hi Frank, can you tell me why is there an accommodation module and a standard module, and can the standard be upgraded to a accommodation?
So when the BCCM Act arrived, they had a whole set of rules that applied to everybody corporate at the top, and then underneath it, it was designed to hopefully allow some flexibility for individual styles of bodies corporates to have different sets of administration and that sort of stuff. So at the moment, accommodation and standard are the two big ones we see from a management rights perspective. There's commercial, there's small schemes, there's two lot. In theory, there was going to be a tourism one, there was going to be a retirement village one, but they haven't arrived. So, and at the start, the accommodation module can only apply if you're predominantly accommodation lots. And accommodation lots means that they're rented or available for rent. And one of the big misconceptions is that that's not short term, that's long term as well. So, and predominant got litigated a while back. Effectively, it means you need to have resort style facilities and more than 50% of the lots rented, not necessarily through you, through Airbnb, third parties, LJ Hook around the corner. And if you are that, you can take advantage of the accommodation module. So what you need to do is to have a special resolution, which effectively is 2/3 of those people who voted in favour of it, 66%, to change module, and then you need to enter into a new management rights agreement after that to take the benefit of that module, and then you can. So there was a window from 97 to 2000 that had a short form change of module, which was ordinary resolution, so a lot of people slammed it through then. We probably do, I wrote a newsletter on that a little while back about changing modules. It's not a difficult process handled right, but to me that's one of the ones you really do want the committee on board for. If the committee's not on board and they rally against it, it's really hard to get there. And that, for me, changing modules doesn't mean a whole lot of difference. And effectively, the only differences between the modules at the moment are length of term and management rights agreements. For all other intents and purposes, they're identical. So, and the question then is, so if you do get across the line from a module perspective, it's, do you do them both at the one time, go module, new agreement, or do you try module, see where you go, and then do new agreement after that? And the other thing with the agreement is I think it's dangerous, subject to where you're sitting, to go at full freight 25 years up front, maybe you go 15. Just get people used to the idea, and then you can top it up after that, because 15 is better than 10.
I had a question, Frank.
Yes, mate.
Do you have a preference for sale whether a complex has all PO Form 6s or a mixture of PO Form 6s and PAMDAs, or it doesn't matter to you?
Do not care. As long as they're all valid, I'm fine. So, yeah, literally doesn't matter. And you see, there's one accountant in particular that will always put in his report, I recommend that you update these things to Form 6s, when that is just completely and utterly unnecessary. Why you go and get more paperwork for the sake of it when what you've got's fine is beyond me.
Okay, great. Yep. All right, so we might take this as the last question.
I know we're running out of space on the video. Frank's going to hang around for those of you that want to pick his brain at the end of the session. So, last question. Thank you.
Thank you very much. But actually, I have two questions.
Last two
Thank
questions.
you. And the first question, but they are all about the top-up. And the first question is on a contract saying that the top-up can just only be done on a certain period, but the agent may say that actually the top-up can be done anytime. The question is, how often or what's the time should the top up to be done?
You can vary your agreements to add 5 years once in every body corporate financial year. So the body corporate financial year is going to be whatever 12-month period its budget runs for. Once you put one up, so if you run one at the AGM, you can't do it again that financial year. Okay. Regardless of the outcome, whether you win or lose. If you lose, you can't do it. If you win, you can't do it. You've got to wait for the next financial year.
But if you got one, so can you, when can you do next?
The next financial year. So if you got up at your AGM today,
yep.
You can't, if your AGM was today, that would mean your end of financial year is 31 January. You can't consider another top-up motion until February next year.
So that means that no matter the original agreement said?
Correct. The agreements can't, that's what the legislation says, so the agreements can't override that. So if you wanted to go for 10 years, for example, you'd need to do a new agreement. You can do a new agreement, but that's then for a longer term than that 5-year variation.
Anyone want to be buried in their management rights? So we all effectively have a plan to sell at some stage, virtually the moment we buy our rights. That could be for some of you, and I've known clients of mine in businesses for nearly 20 years, but for most of you there's an average time frame. To be planning for some of these things now, so that if a circumstance comes up that perhaps you weren't planning for, you're nonetheless ready to execute on that quite quickly. And the thing I loved about today was there are things that you can do without expense and without needing necessarily a solicitor. There's things you can plan for now. So once again, thanks a lot, Frank. It was really great. Frank's going to stick around. For those of you that have to get going, we understand. Thanks again.